Okay, welcome everybody. My name is Claire Mambiella. I'm the Library Law Consultant for the Library of Michigan, and I am here today to talk to you about um, some library law resolutions. And you know, in January is always a time where we kind of pause to reflect about things we want to accomplish during the year and some things that we can do as far as improvements go to a variety of things in our personal life and our professional life. And so I figured that kind of carries over to public libraries. And so I thought it would be a good idea to kind of take a moment to kind of look at some library law related things that would be good to incorporate in some resolutions this year, some goals, if you will, for things that would be good for public libraries to keep an eye on or to keep in mind over the year as far as library law is concerned. I need to give a little bit of a caveat in that I am here to provide information on the law and information, and also areas where you can obtain information on different topics within the law that apply to public libraries in Michigan. What I cannot do is provide specific legal advice. If you have a situation where you need specific legal guidance and legal advice, it's always best to check with your library law attorney. If you do not have a library law attorney, I can certainly provide you with some lists of law firms and attorneys across the state that do practice municipal and library law. So please don't hesitate to contact me, and I'd be happy to share that with you. So the first resolution that is, I think, arguably one of the most important, and that's to get to know and read your establishment law and your establishment documents. And so you say, okay, well, what do I mean by that? And I've been trying to discuss this a lot lately because it's very, very important that as a public entity and as a public library and just as a business, that the people who are in charge of that business, so both the boards as well as the library director, understand what their powers are, understand how their establishment is supposed to be set up, understand how it's governed, understand what rules apply. And in order to do that, you need to read your establishment documents. So in Michigan, public libraries are established by statute. And there's various methods to do that. And there are 10 different establishment types in the law in Michigan. So there's 3 different city establishment types, 3 different township establishment types, 1 village establishment type, 1 district library establishment type, 1 school public establishment type, and 1 county library type. So there's many different ways to establish a library in Michigan. Every single one of these types has some similarities, and every single one of them has some differences. So the fact that maybe you, as a director, had worked in a township library and now you work in a district library means that, yes, many things, particularly day-to-day things, are probably going to be very similar. But some fundamental things that may be more having to do with the behind the scenes, like financing and governance, are really, really different. So, and your possibly your relationship with your municipalities can be very, very different. So that's one of the reasons why it is extremely crucial that the people in charge of these facilities understand how they're established, what their establishment type is, and what are the rules or the laws underpinning those establishments. So your establishment type, if you don't know it, can be discovered either through our files here at the Library of Michigan. We keep files on every library. We don't necessarily have every bit of information on every library. We have quite a bit. There are some libraries here where their legal establishment folder is empty. So occasionally we have a situation where we have to kind of do some research. Sometimes you can figure out your establishment through the setup of your board and your funding. So for example, if you're a library with a 6-member elected board and you have a millage, then odds are that you were established under the City, Village and Townships Library Act, also known as PA 164. Because those establishment types, those particular factors, rather the elected board and millages, are all in keeping with that particular establishment type under that statute. Sometimes your millage language gives an idea. Your millage language may indicate district. Your millage language, especially the initial millage, may indicate that you're a PA 164 or a city library. And very often I refer to newspaper articles. I will do research going back in the historical newspapers to get an idea of when a library first opened, when a library passed a millage, and all of those kind of clues can help me get an idea of the establishment. It can take a lot of footwork, but it's definitely worth it. For those of you in libraries, those public library directors, you may want to rifle through your files and kind of go and talk to your municipal clerks, because it is possible that if you don't have a folder on establishment, your municipal clerk might have some kind of idea. And if you have any kind of idea of when your library started, the other thing to do is to go through the minutes of your municipal governing body from that time period. And minutes are supposed to be kept indefinitely. So again, it could be a bit of some legwork. It could be kind of quite a research job, but it should be pretty possible to do. The other thing you could do is talk to your attorney. If you've had a library law attorney for a while, they may know what your establishment is, and it may be in their files, because chances are they would have had to have been involved. Now, why does this matter? Why do we care what our establishment law is? Well, I mentioned a little bit about, it's important for you to understand the rules that govern your library and how your library is supposed to be set up. But one thing to also remember is that your establishment statute is the piece of information that provides your library with its legal identity. So if you look at it like any company, right? So any corporation, the way that you would create a business is you'd have to incorporate, right? And there's lots of different kinds of corporations that you could have. But in order to get the law or society or the government to recognize your business as a business, you have to go through some kind of legal process. So whether that's incorporation or whether that's establishment, you have to follow some kind of guideline. And it's those guidelines, when everything is done, that enables your facility or your business to actually hire people, have money, spend money, enter into contracts, and do all of the things that businesses do. In other words, it kind of creates the personal identity of your particular facility. And as it says on the slide here, in order for anybody to have rights or powers, or any entity to have rights or powers, there has to be some kind of official acknowledgement of its existence within the law. And the way that for libraries that happens is through your Establishment Act. So let's start with districts. So district library agreements. Many establishment acts, libraries are pretty much established by virtue of either a vote for a millage or through a resolution from a municipality or through the passage of an ordinance. So, those are the ways that a lot of municipal libraries get established. District libraries are a little bit different. District libraries, again, depending on how the circumstances under which it's formed, either go to a vote in order for it to be created, or municipalities get together and agree that they're going to create it. And in both cases, there needs to be resolutions from the municipalities. But along the way, these municipalities that are deciding to partner and create a district library also have to come up with a contract. So they have to come up with an agreement. And under the law, it calls it a district library agreement. And within the District Library Establishment Act, it's actually Section 4 of the District Library Establishment Act, that lays out exactly what criteria these district library agreements have to contain. So what specific types of clauses this contract must contain. Now, it doesn't give you the exact wording because a contract is such that, multiple parties, whenever you have two or more parties that are creating a contract, they can agree whatever they freely agree to in most circumstances, as long as it doesn't contravene any written law, is okay. But what the District Library Establishment Act does is it says, okay, A, you have to have an agreement, and B, this agreement has to contain certain types of information, such as how big is your board going to be, because the law provides you some options. What is the board's terms going to be, because the law provides some options. Is your board going to be elected or appointed? How is the library going to be funded? How do members join the district? So there are certain questions like this that the law requires has to be included within this district library agreement. It is up to the municipalities and the attorneys to decide exactly what those words are. So this district library agreement provides this underlying framework of some specific guidelines and specific rules that the district library has to abide by. So you have the statute, which provides a broad framework, and the broad identity says, okay, this is a legal entity and the people here have done everything according to the law in the correct way. And we think that they're responsible parties to be able to create a district library. But then the district library agreement gets down to some of the nitty-gritty and says, well, this particular district library is going to have 8 board members, and each of the municipalities that is participating gets to supply 4 board members, and those board members are going to be appointed, and they're going to be appointed for 3 years each, and they're going to be staggered in this way. Or they could say they're all going to be appointed for 4 years and they're all going to leave at the same time. And 4 years is the maximum that district library boards can be seated. You also have to put in, how are you going to amend this agreement? What if along the way someone else wants to join the district library agreement? Well, then you have to amend it. What if the board along the way evolves in some way and decides, we think we want to change some of the way we do this? Well, then you have to amend the agreement. Well, how does the agreement get amended? That's up for the individual municipalities as well as the existing library to determine. And the district library agreement would specify how that happens. So the district library agreement is a little bit more of the nitty-gritty, and the law is a little bit more of the broad. Now, there are some specifics in the law, but just talking in a general sense to get an idea of why the district library agreement is important when you have a law, that's why, because they kind of work together. The law provides the overall authority, and the district library agreement provides the more specific detail on how that library is supposed to be handled. Another good example is the District Library Establishment Act specifies a list of powers that boards may have. District library boards may have. Doesn't say they have to have those powers. It is the municipalities that can decide within the district library agreement what powers the boards should have. So that's just another example. And that's why your district library agreement is so important, because boards can't assume that every power listed in the District Library Establishment Act is necessarily theirs for the wielding. So it's important that you read your District Library Establishment Act and you read your District Library Agreement. If you're a city library, you read any ordinance or resolution that formed you, plus you read the law that you were established under, whether that's the home rule city law or whether that's PA 164. And the same is true of township libraries and county libraries. Make sure that you double check and you read so you have a very good understanding of the boundaries and parameters within which you are able to function and what your responsibilities are. The second library law resolution is policies. So policies, we all have a whole bunch of them for libraries, right? So you have policies for the general public, you have external policies, policies for the public, policies for how staff deals with the public. You may have facility policies, you may have meeting room policies, you may have display policies, and then you also have internal policies like employment policies, like maybe certain policies for things like FOIA, or maybe you have policies for use of computers. Maybe you have internet policies. Maybe for staff, you have policies for dress. So all of these policies are library policies. Every single one of these policies are policies that the board and the director should collaborate on, right? So the board should not be creating policies in a vacuum, and the director should not be creating policies in a vacuum. Now, let me clarify this. When you're talking about, certain, there's policies that are, let's say, major policies like employment policies. Okay, so like how many times can an employee be late without being, in trouble? How many, what is the criteria that an employee has to work? How many hours do they have to work before they can become vested in certain benefits? Do you have a nepotism policy that determines whether or not people who are related can be hired in the same library? So these are policies that are more higher level policies. So these are policies that can have very significant ramifications and somewhat restrict the employees. So these are policies that would be important for the board and the director to work together on. But definitely at the end of the day, the board would have to approve it. Then you may have policies that are a little bit more pedantic. Things like a person can't be logged into 2 computers at the same time. A patron can't have more than 3 video games checked out at the same time. Like, these are policies that are a little bit more lower level policies. These are the kinds of policies that the director should be empowered to pretty much put into place. And that a lot of that is just a practicality. If the director has to go through the board for every single basic policy, it can really hamstring the functions of the library. That's not to say that the director should not notify the board that certain policies were put into place, and perhaps why. But if you need to put a policy in place saying that people can't monopolize a photocopier for more than 25 minutes, that's not really something the board probably needs to worry about, right? That's something that really probably comes into being because the library has realized it only has one copier and it is very popular. So there's policies and there's policies. But for those higher level, larger impact policies, it is very important that the board is involved and approves them. And it could also, be the board's prerogative to decide what policies it wants to have input on. My recommendation would certainly be that the board doesn't concern itself with a lot of very small policies, because it hampers the director's ability to do their job, and frankly, it just takes up too much of the board's time. As far as the policies goes, you want to make sure that everyone has read all the policies, particularly those higher level policies, employment policies, broad, the patron behavior policies, sexual harassment policy, FOIA policy, copyright policy. You want to make sure that any of these policies that could potentially inflict a lawsuit or could potentially result in someone being fired, you definitely want to make sure that the board has read it, the director has read it, and everybody understands it, and everybody, has it's gone through the process to be approved, and that your attorney has looked at it. You want to make sure any policy is legal, right? So does it have due process? Does it have an appeals process? Is it conforming with current law? Right? So you can't have a policy that says people can't look at pornography, because pornography is permitted under the First Amendment of the United States. You can have a policy that limits where people look at pornography in the library, but you can't limit, you can't say nobody can look at pornography. So you want to make sure that your policies are vetted through your attorney. You want to make sure your policies are enforceable. You can have the best policy in the world and the most well-meaning policy, but if it is something that is just impossible to enforce, if you have a policy that says, well, anybody coming in the library must wipe their feet before they come inside. Well, that may be a good policy because maybe you have an expensive carpet, or maybe you have a nice floor, especially in the winter when salt can get on there. But that's going to become impossible to enforce especially if you have a busy library. So with that, really the best you can do is have a sign that says, please wipe your feet, and provide a rug or a carpet on which people can wipe their feet. But to enforce that seriously is really problematic. So you want to make sure that you have policies that are reasonably enforceable by your staff. You want to make sure that there's a good enforcement procedure. You want to make sure the staff is trained, that the staff understands not only the policy itself, but understands the purpose of the policy. Because if you understand the purpose of a rule, then it becomes a lot easier to make the correct judgment calls when you have to make a hard judgment about whether someone has violated the rule or whether to call someone on violating a rule. Because as we all know in libraries, a lot of things are not as black and white as they may appear. But if you understand the reason for a policy or what that policy is trying to achieve, then it becomes a lot easier for your staff to ensure compliance with that, and frankly your patrons to ensure compliance with that particular rule. You need to make sure that that rule is enforced, or that policy is enforced consistently. You can't have a policy that is in place only for certain people. That's completely problematic. A library as a government entity, you're a limited public forum, and that permits you to have restrictions, but the restrictions have to be neutral and equally applied. So that means that you can't limit access to like your meeting room based on the subject content of whatever the group wants to talk about. You can limit it based on whether it is a commercial group versus a nonprofit group. But you can't, once you do that, you can't say, well, every commercial group but my friend who sells LuLaRoe. You can't do that. You have to make it consistent. If you're going to have no commercial entities or businesses allowed to use your meeting room, then it has to be across the board, no matter who it is. If you're going to permit nonprofits, then you have to permit every nonprofit that asks. And that can lead to some difficult choices, but that is the nature of a public entity. You want to make sure that people are noticed, that the policies are available for people to see. If you're going to hold your patrons to a patron behavior policy, you should have that policy posted so your patrons can see it. You want to make sure it's somewhere in the library. Make sure it's on your website. You can make sure it's accessible from your desktop of the library's computers, wherever you want to have it, but you want to make sure that it's easily accessible to the patrons that it applies to, so that the patron is under notice that if they are a teen and they're smooching, or not even a teen, if they're anybody, and they're smooching in the back corner of the library that they're going to be asked to leave. That's, you want to make sure you can't fault someone for something they didn't know was wrong. You want to make sure you update your policies, right? So if you have policies and you haven't looked at them in 5 years, well, I would probably pull them out and take a good look at them. If you have policies and they were created by a prior director or a prior board and nobody in the current administration has looked at them, that's problematic. You want to take a look at all your policies, and you should do it on a fairly regular basis. I would say you should do it probably at least every other year, maybe start to kind of go rotate through them all. Certainly if your board completely turns over, or if you get a new director, that's definitely a time when it would be good to take a look at them. You certainly shouldn't go 5-10 years without reviewing them, because sometimes the law changes, right? So we know there's a bill in the legislature right now on Privacy Act that could change some of your policies. There's changes in FOIA that occur from time to time that could change your FOIA policy. There could be changes in other areas of the law, broader areas. There's a movement right now dealing with 3D guns and whether or not the federal government is going to make them legal. And that could have enormous effects on policies. So there's all different kinds of things that can affect library policy. So that's another reason that you want to keep your policies current, and also keep yourself current in certain areas. So if you hear about a new law that could affect your policies, you might want to, kind of take a look at that or ask someone. You can ask me, you can take a look at MLA's advocacy stuff, and see exactly how it's going to affect. And, sometimes you might have to change policies on the fly, if a change comes that quickly. Sometimes there's changes in your community or your society. There may be things like, drag queen story hour is something that is a result of some large changes, particularly in certain communities. There are some communities right now where that change still hasn't occurred. So, you have to have kind of a hand on the pulse of your community to determine some changes to policies. And then changes in, your individual library's philosophies and how you do things, like going fine free. It's possible a lot of libraries are talking about that. You may make, certain changes in things like that, or food and drink. And then, of course, your policies have to reflect that. You want to double check things like your security policy, and how you deal with, if a crime occurs. So these are all policies that are pretty important policies and should be things that, are almost constantly being reviewed, to make sure that not only are they reasonable and legal, but that they're working for your particular library, and that all of your staff, particularly the people who are going to be responsible for enforcing those policies, understand exactly what the expectations are from the administration as to enforcement of these policies and how enforcement should occur. And that, even how to enforce it may require some training. And then you have things like HR policies. You're hiring, you may be in a library that you've been there for years and years, and you just kind of cut and paste certain things to create, job notices. But, things are changing, and there's certain things that used to be in some job notices that are no longer attractive in job notices. And some of those have to do with these physical requirements. So you want to be really mindful of, you might not want to say that the job requires vision or requires hearing or speaking, because that's telling someone with a physical challenge that they're not wanted. What you would want to say is, we need somebody, the person must, have, must be able to see, or must be able to view a computer with accommodations. or must be able to hear patrons with accommodations, or must be able to communicate with accommodations. So you want to make sure that, you know, your job descriptions are written in an inclusive and equal way in order to appeal to that area, those people who may want to work in your library, who represent those groups. So that's very important. And if you need some examples of that, we'd be happy to help you with that. And I've included some links here that can help with that too. Your employee handbook. You might want to take a look at your employee handbook. If you have an employee handbook and you have employee procedures, particularly like discipline procedures, and those procedures do not kind of reinforce your at-will status, and your at-will status is something you want to enforce or you want to reinforce, then I would talk to your attorney, because it can be problematic and it can affect your at-will status if you have certain policies and procedures that provide an employee with some kind of reassurance that if they follow a certain path, their chances of being fired are reduced. So, you know, it's all about creating expectations. And so you want to make sure that your documentation clearly notifies the staff that, and this is if you want to, and you know, whether you want to or not is something you could discuss with your attorney. What are the pluses and minuses of at-will? Michigan is an at-will state, which means by default you're at-will. But sometimes things you do as far as policies and procedures can affect your at-will status. So that's something you want to be aware of and possibly discuss with your attorney to see what you can do to mitigate that. Your board bylaws. So board bylaws are the policies for the board, not the policies for the library. So your bylaws are rules for the board, not rules for the library. So you want to make sure that your board bylaws reflect the fact that these are rules of procedure for the board. They provide boundaries for the board. Things like attendance, being prepared for meetings and reading packets, how the election of officers is going to occur, how you recruit new members if a member leaves. All of these are things that should be in the bylaws. How meetings are conducted, how the agenda is going to be sent out, who, you know, what the president is responsible for versus the vice president versus the secretary. All of these things are things that should be in the bylaws. And again, these should also be constantly reviewed, at least every couple years, to make sure that they're in keeping with the culture of the library, in keeping with the current board and how the board wants to do things, and with the law. So this is important because even though libraries are public places, and they're public buildings, they are limited public forums, which, as I said before, gives the library autonomy, a certain amount of autonomy to put in place some regulations. But those regulations have to be reasonable, right? And they have to be legal to regulate services and processes. You want to make, and the way the law states it is what's necessary for public safety and to operate the library in a particular, in a reasonable and responsible way. Any policy or regulation the library implements has to be reasonable and neutral. Okay, can't target any particular group, and it has to be consistently applied. And again, I cannot stress that consistent is a major thing. Right? So whether or not a policy is neutrally and consistently applied can mean the difference between a library having a good policy and a library being sued. So it's really important that your staff understands that policies are there for behavior, not for people, right? You're not restricting people. You are helping people with behavior. You are regulating behavior and regulating service. You're not regulating people. So therefore, you want to make sure it's in the library's best interest to keep everything current and up to date and to keep everybody trained. In the end, it makes things a lot easier and a lot more comfortable for everybody, for your patrons and for your staff. Privacy. So right now there is a bill sitting in front of the legislature that would create some change to the Library Privacy Act. And the Library Privacy Act and privacy in libraries really revolves around the notion that people have a privacy right in protecting the information that they wish to have. So in other words, all of us have a right to have the information regarding what we read and what websites we go to and what things we like to look at and what things we want to learn about. We have a privacy right in ensuring that that information is not disclosed without our permission. Even if we've violated a library rule, or in some cases we've violated the law. Right now, the only people who can give permission for information that is contained in a library's record, so patron information including name, address, likeness, are parents for kids, because the law is written to say whoever is responsible for the return and the replacement of library items. So whoever's responsible for paying the fines and paying for replacement of damaged items is the person who is in charge of the account. So usually for children and minors, that means the parents. So that means parents have access to their kids' records. Whether we agree with that or not is beside the point, because the law says that parents have access to their kids' records. Right now, besides permission, the only way to give information on that's on someone's patron record is through a warrant, and that means the police have to obtain a warrant. And right now, it doesn't matter if the library is the victim of a crime, still has to obtain a warrant. The second half of the Library Privacy Act has to deal with children's exposure to sexual content. Libraries have a choice to either filter, but if they filter, there has to be a mechanism to turn off or remove that filter if an adult requests it. Or libraries can have a procedure or a policy where they manually inspect children using computers to make sure that the children are not accessing content on the internet that is sexually charged or that is sexual content. So does this mean that if you have a patron who is looking at inappropriate, let's say pornography, you have an adult looking at pornography and a child walks by, that's a violation of this Privacy Act? Well, it's a little unclear, okay, because the adult has every right to look at pornography. And if the adult is looking at the pornography and the child just walks by, the general consensus is that, it is up to the parent to police what the child is exposed to. So it could be argued that a child could walk into the adult section and pull an art book off the shelf and look at naked pictures. A child could go into the adult and look at the Kama Sutra or look at the Joy of Sex. And that's not a violation. So it's not up to libraries to keep children insulated. It is up to libraries to prevent children from getting on the computers and in that interaction being exposed to sexual content. Now, that doesn't mean it wouldn't be prudent to maybe have, if you have a computer area where adults and children view content together, then you may want to invest in some privacy screens where nobody can see what people are looking at on the internet for certain computers. Maybe those are the computers reserved for adults. And then the kids' computers are open that anybody can look at it. So there's different things libraries can do and have done to assist with this particular issue. One of the hardest things is to identify that sexual content, to identify obscenity. So there's a difference between someone looking at pornography and someone looking at like child pornography, or someone looking at obscenity. Pornography and obscenity are not the same thing. Obscenity is not protected by the First Amendment. Pornography is. And there would be, I need way more time than is left in this webinar to really explain this, but I can provide some access to information and sites that would explain this. On the next slide, I have some links to some sites that do a fairly good job of explaining these distinctions, but it does require training of your staff, right? Everything that shows a part of the human anatomy is not necessarily pornography, right? And every person sitting at a computer looking at a child on a computer is not a child predator. So, and there are gray lines, so it gets difficult. So these are some things that can be very useful for libraries to have training for their staff. Why this matters. So the main reason why this matters is privacy is very important to libraries. It's a tenet of library ethics since pretty much since librarian the profession began. You know, going research all the way back into the 18 and 1700s talks about privacy, and particularly particularly the 19th and the 20th centuries. There's quite a bit of discussion about it. So it's this balance between protecting someone's privacy and their right to read, and making sure your library is safe and supporting the law enforcement in their efforts. And it's not a very easy task. But remember, I said if you understand why the law is in effect and what the purpose of the law is, it can help you make some judgment calls. And this is one of those situations. As the original intent of this law was to prevent police from fishing in circulation records in order to find people who may have committed crimes they already knew about. So they knew that somebody tried to rob the bank. And so they go to the public library and they want a list of everybody who has checked out books on locks and on safes. That's phishing, right? Someone calls in a bomb threat to the high school. So then the police want to see every computer file of who's been on, what teenager has been on computers and may have been looking at sites or social media about creating a hoax at the school, or maybe thinking about causing some kind of damage at the school. And these are all practices that are not permitted. Having that kind of phishing is very dangerous. So that's originally what the law was put into effect for. And over the years in Michigan, they've tightened up the law a little bit by then protecting personal information like addresses and names. And again, it doesn't make it any easier to enforce, but understanding the purpose can make it a little bit easier to make some distinctions, right? So if the library if it's clear theft and the library needs help from the police, well, right now they cannot provide the name to the police, but they could protect evidence like surveillance footage, like computers. They could set them aside. There's things they could do to collaborate with the police and wait while the police get a warrant in order to get the information. Now, as I said, there are some changes occurring on this, and there could be some fairly significant changes. So as the bill works through the legislature, this is going to be a slide that will likely change in the next time I present this. Some additional ideas, advocacy, right? So how do you talk to your legislators? Have you met your legislators? There's everything from penal fines to annual budgets at the federal level are important to libraries. And you want to make sure if there's something in about your library establishment type or something about your day-to-day library world that is really difficult for you, and you say, my goodness, why can't we just X? Well, you may want to talk to your legislator about it. You may want to say, look, I don't understand, for example, why someone can't bring a gun into a school, but they can bring it to story time at the public library that is right across the street from the school, or that's right down the street from the school, or that has school children in it. So, those are some of the things that by talking to your legislator, it's possible that some stuff could change. I find that a lot of legislators, everybody loves their library. I have never yet not met anybody that says, oh, I hate libraries. I don't want to give them anything. Ugh, I don't even know why we have them. Some people may say, oh, we're not going to have libraries. We don't really need libraries right now because, and those people tend to be either people who don't use the library or that tend to be like municipal officials. I have never heard a legislator say that they don't see why they need libraries. So most people in those positions clearly understand that libraries are a good thing. And most of your community welcomes your library. So one of your best advocates and a really important start on the path to change that you want to see is by talking to your legislator, because they're the ones that are in charge of creating the laws that govern your library. If you want to learn more about advocacy, there's lots of ways to do it. American Library Association has a good page on advocacy. The Michigan Library Association has information on advocacy. You have options to get involved through Advocacy Day with Michigan Library Association, which is in April, and with National Library Legislative Day, which is the federal advocacy event that occurs in May every year. So I would strongly recommend that if you are interested in advocacy and you'd like to have some more experience in it, that you take advantage of those and you get involved and get to know your local legislators. And you know what? Get to know your local municipal officials too, because in their way, they are also legislators. So if you have a municipal official that's poo-pooing, why do we need libraries? That's the person you really need to connect with and show them why we need libraries. And I realize I'm not telling you anything that you probably don't already know in that regard, but sometimes it's hard to take that first step. So if nothing else, I'd like to encourage you to take that first step. None of these people are people that, are so high and mighty figures that you should feel, bad talking to them, right? So remember, they all work for you. You're a taxpayer and you have every right in this country, it's in the Constitution, to participate in government and to address your government. And that's in how we do it, is through our legislators. Some more ideas. Contracts. If you have contracts, every library has some contracts, whether it's licensing or employment contracts, but you may have service contracts with other municipalities for service. You should also take a look at those regularly. If you have never looked, if you're a library director and you have never looked through your contracts for library service, then I strongly recommend you start with that. And you look through your contracts for service, because you may find that some of your contracts have not been looked at in decades and have not been renegotiated. And, whereas 10 or 15 or 20 years ago, maybe having a contract with a municipality only for penal fines and state aid was acceptable, you may find now that if you're in a community where your legal service area is paying $45 per capita for the library in terms of a millage and their state aid and their penal fine contribution, in terms of what you get for them, but primarily the millage, then, or if their municipality appropriates money, that per capita amount, as far as the millage goes, you know, if you have a legal service area, like I said, that's paying like $45 and your contracted area is getting the same library service and access to the same thing, and they're not paying anything, it's just state aid and penal fines, then, there's a real inequity there. And you're going to have some legal service area people like, hey, why am I paying $45 a year for this when this guy is paying nothing for the same thing? This is my community and my library. If anybody's paying, it should be them. And there have been some real issues in different communities over this. It just takes someone finding out about it. So, what you might want to do is take a look at that in order to make it a little bit more equitable. And also, it will help you subsidize the services that you are providing. There's nothing wrong with asking a municipality to pay a fair amount for services rendered, right? Library service is not free, and library service in most instances costs well above what you're getting in state aid and penal fines per capita. So don't be shy or afraid about renegotiating those contracts. There are some creative ways that you can do that. And again, Kathy Webb and myself would be happy to talk to you about that, as would your library attorney. Okay, so we're just about at the end. And I would like to say thank you very much for listening. If you have any questions or you have suggestions for future webinars, I would be more than happy to entertain those. So I would love to hear them. Please don't hesitate to contact me. You should receive a survey for if you attended this webinar when it was given. You should receive a survey. If you did, please return it, because I would very much, it helps me. Nobody's perfect. I certainly am. I can always improve, and it helps me in preparing my webinars and in presenting them to have constructive criticism. So if you have anything you'd like to suggest, I would be more than happy to hear it. So thanks again. I hope you learned something. I hope it was somewhat interesting, and I hope you have a great rest of your winter, and I hope everybody stays warm. Thanks a lot.